Good evening or good night. This is Marla coming on live to talk about the Constitution. This is my favorite book. And I was just reading up on the First Amendment rights to freedom of speech, regulating the broadcast and cable media, and in Red Lion Broadcasting Co., Inc. versus Federal Communications Commission, Justice White delivered an opinion of the court, which is a really good opinion because it upholds tradition. And I kind of highlighted one little piece of it where he says, where there are substantially more individuals who want to broadcast. This is like YouTube would be a broadcasting network and a cable media type. Well, it says where there are substantially more individuals who want to broadcast than there are frequencies to allocate, it is idle to posit an unabridgable First Amendment right to broadcast comparable to the right of every individual to speak, write, or to publish. And so I wonder if YouTube, being that all of us have a license via YouTube to broadcast, and there is only but one broadcast. What am I going to say? Network. There's only one frequency on YouTube. There aren't many platforms who allow you to broadcast and share your ideas. I wonder if this medium is comparable to that of 1969. If 100 persons want to broadcast licenses, but there are only 10 frequencies to allocate, all of them may have the same right to a license. So if there's only one YouTube frequency, do we all have a right to broadcast our ideas, speak and write and publish? Does YouTube have a right to limit speech of individuals to share ideas, write and publish their ideas? Are they being, this is something that needs to be answered because, But if there is to be an effective communication by radio, if there is to be an effective communication by the internet, by YouTube, only a few can be licensed and the rest must be barred from the airwave. It would be strange if the First Amendment aimed at protecting and furthering communications prevented the government from making radio communications possible by requiring licenses to broadcast and by limiting the number of licenses so as not to overcrowd the spectrum. So is YouTube trying to limit the number of licenses or of voices to broadcast? Is YouTube being handled by government officials from behind the screens like Facebook is? When I was doing research on Facebook, I discovered that a lot of the people on Facebook's board of directors is from the government. I wonder. By the same token, as far as the First Amendment is concerned, those who are licensed stand no better than those to whom licenses are refused. A license permits broadcasting, but the licensee has no constitutional right to be the one who holds a license or to monopolize a radio frequency. So should YouTube be licensed to allow its users to broadcast? I don't know. Or to monopolize, because they're really monopolizing the internet frequency to the exclusion of his fellow citizens. There is nothing in the First Amendment which prevents the government from requiring a license to share his frequency with others and to conduct himself as a proxy or fiduciary with obligations to present those views and voices which are representative of his community and which would otherwise by necessity be barred from the airwaves. Nor can we say that it is inconsistent with the First Amendment goal to producing an informed public capable of conducting its own affairs, to require a broadcaster to permit answers to personal attacks occurring in the course of discussing controversial issues, or to require that the political opponents of those endorsed by the station by YouTube be given a chance to communicate with the public. Otherwise, station YouTube owners and a few other networks like Rumble would have unfettered power to make time available only to the highest bidder. So I wonder, is YouTube making time only available to those in the Democrat Party, the highest bidders, to communicate only their own views? So are conservative views being barred? And is YouTube favoring only one-sided view on the public issue, people and candidates, and to permit on the air only those with whom they agreed? There is no satisfactory sanctuary in the First Amendment for unlimited private censorship. There is no sanctuary in the First Amendment for unlimited private censorship operating in a medium not open to all. So this medium that I am communicating with you is open to all of us. And YouTube cannot censor, even if it's private. It is strenuously argued, however, that if political editorials or personal attacks will trigger an obligation in broadcasters to afford the opportunity for expression to speakers who need not pay for time, whose views are unpalatable to the licensee, then broadcasters will be irresistibly forced to self-censorship, and their coverage of controversial public issues will be eliminated or at least rendered wholly ineffective. Is that what YouTube is doing? I don't know, you tell me. At this point, however, as the Federal Communications Commission has indicated, that possibility is at best speculative. However, it is not speculative in today's world, where it was years ago in 1960. The communications industry, and in particular the networks, have taken pains to present controversial issues. In today's world, 2020, the communications industry is going through great pains to not present controversial issues. And even now, they do not assert that they intend to abandon their efforts in this regard. It would be better if the FCC encouragement were never necessary to induce the broadcaster to meet their responsibility, and if experience with the administration of those doctrines indicates that they have the net effect of reducing rather than enhancing the volume and quality of coverage, there will be time enough to reconsider the constitutional implication. The fairness doctrine in the past has not had no such overall effect. This will occur now seems unlikely. However, since if present licensees should suddenly prove tenuous, the Commission is not powerless to insist that they give adequate and fair attention to public issues. It does not violate the First Amendment to treat licensees given the privilege of using scarce radio frequencies. So today, we have scarce internet frequencies as proxies for the entire community. So YouTube is a proxy for the entire global community, obligated to give, and so is Facebook, and obligated to give suitable time and attention to matters of great public concern. To condition the granting or renewal of licenses on a willingness to present representative community views on controversial issues is consistent with the ends and purposes of those constitutional provisions forbidding the abridgment of freedom of speech and freedom of the press. So YouTube is a medium where pretty much anyone can present their views and have a discussion in the comments below on those views. And the press has the ability to come onto YouTube and allow the global community into our discussion, which is kind of phenomenal. And it allows for politicians to really get to know the public. But this censoring really has to go. It's not allowed. The fact remains that existing broadcasters have often attained their present position because of their initial government selection in competition with others before new technological advances open new opportunities for further uses. Long experience in broadcasting confirmed habits of listeners and viewers, network affiliation, and other advantages in the program procurement give existing broadcasters a substantial advantage over new entrants, even where new entrant is technologically possible. These advantages are the fruit of a preferred position conferred by the government. Some present possibilities for new entry by competing stations is not enough in itself to render unconstitutional the government's effort to assure that broadcasters' programming ranges widely enough to serve the public interest. So, broadcasting must serve the public interest. And if YouTube is censoring conservative views and allowing only liberal and leftist views and not allowing for attacks on politicians and letting those politicians answer those attacks, I think that is a violation of our constitutional right to be informed, an informed populace and citizenry. So if I were a judge, I'd say, YouTube, you need to be paying a fine, and I'm going to make you're going to have this license, and if you violate this license, this is what's going to happen. I don't know. In view of the scarcity of broadcast frequencies, so I guess there's scarcity of broadcast frequencies today on the internet. We have Rumble, but Rumble is not YouTube. We have Vimeo, but that's a paying, it's not a free network, and it's not a YouTube. The government's role, here it is, the government's role in allocating those frequencies and the legitimate claims of those unable without governmental assistance to gain access to those frequencies for expression of their views. We hold the regulations and ruling at issue here are both authorized by statute and constitutional. So I guess governments could So, what do you think? Comment below and let me know. What do you think of this justice's opinion? So I guess the next question is the fairness doctrine. Does it apply today to what's going on online? What do you think? Let's see. The fair trial and free press controversies. The development of television along with newspaper, along with internet. Okay, I'm plugging that in because this was in 1997. And their coverage of sensational trials led to a series of fair trial, free press coverage, adverse prejudicial trials, and trial publicity. Nah, that's not relevant. This symbolic speech is interesting, but not relevant. So freedom of the press. In essence, with Facebook and YouTube, a lot of individuals have the freedom to express their views and their ideas and to get right in their politician's face. And so I think that's a wonderful thing in our era, but it's kind of awful that YouTube and Facebook are censoring speech that should be allowed. But that's my opinion. And I just want to inform you on our rights in the Constitution to freedom of speech and press. Here is chapter Session Laws of Minnesota 1925 provides an abatement as a public nuisance of a malicious, scandalous, defamatory newspaper magazine. Let me freedom of the press. That's for another video. Anyways, if you like this video and you like the case that I just read, please comment below and let me know what you think. And please go and get this book. I will put the link down below in the comment so that you can purchase it yourself and have fun twisting these laws in your head and wondering if YouTube and Facebook and Twitter are violating our constitutional amendment. Granted, the First Amendment rights is for the government. The government cannot abridge our rights, but definitely there is some say in regulating communications and monopolies. So I will sign off, and until the next video, thank you very much, and I hope you enjoyed. I'm an independent paralegal and also an independent consultant for Osborne Books and More. So I love children's books. I think that our books are the best books around. And truly, Osborne Books and More makes the best literary books, the best literature, the best illustrations of any children's books around. So if I were you, I would go to k4699.myubam.com and try our books. Buy one book, buy two books, sample it, see if you like it. And if you love it, please give me a call and let's host your very first show online, socially distanced, and mask-free. Anyways, talk to you later. And